Welcome to this explainer, future chartered accountants. Listen up, CA inner students. If you want to absolutely conquer corporate law, you are in the exact right place. I know you've probably studied this chapter once already, but right now, it is time for the ultimate rapid-fire revision masterclass on management and administration, covering sections 88 to 115. We're going to decode the logic, expose all those sneaky examiner traps, and lock these concepts into your brain so you can score maximum marks. Get ready, because we are moving fast. Okay, here is our game plan for today. Number 1, the big picture. Number 2, registers and returns, covering sections 88 to 94. Number 3, general meetings, sections 96 to 104. Number 4, proxies, voting and resolutions, spanning 105 to 115. And finally, number 5, exam traps and wrap-up.
Part 1, the big picture. Now, before we just start blindly memorizing sections, we really have to understand the why. Like, why do sections 88 to 115 even exist in the Companies Act? Well, think about it. The people who actually own the company, the shareholders, are rarely the ones running it on a daily basis, right? That's the management's job. This entire chapter exists for one single absolute reason: corporate transparency. It's essentially a giant shield designed to protect the owners from rogue management, making sure that major decisions are made openly, democratically, and completely by the book.
Let's dive into Part 2, registers and returns, covering sections 88 to 94. Under Section 88, a company absolutely must know exactly who owns it. Now, there are a few forms you just have to memorize, but don't worry, I've got a quick memory trick for you so you don't confuse them in your MCQs. Whenever you see MGT, I want you to think of your general management registers. So MGT1 is your register of members, MG2 is for your debenture holders, and please star mark MGT7 in your notes right now. The annual return is an absolute ICI favorite for MCQs. Now, on the flip side, whenever you see BEN, think beneficial. So BEN 1 is specifically for the significant beneficial owner declaration. Speaking of beneficial owners, the magic number you need to remember is 10%. Under Section 90, a significant beneficial owner, or SBO, is an individual who indirectly holds not less than 10% of the beneficial interest in a company. Let's make this super practical. Suppose Reliance sets up a massively complex web of subsidiary shell companies. The SBO provisions exist so the government can look right through all those layers and find the actual human being sitting at the top who indirectly controls at least 10% of the interest. And that person, they must file Form BEN 1 within 30 days.
Now, once you have these registers, how long do you actually have to keep them? Section 94 dictates the preservation timelines, and mark my words, ICAI loves to test these differences in exams. The register of members, that's permanent. It is the core identity of the company's ownership. But the register of debenture holders, you only preserve that for 8 years from the date of redemption. And the annual return, 8 years from the date of filing. Seriously, don't let the examiner trick you into thinking everything is permanent.
Moving right along to Part 3, general meetings, covering sections 96 to 104. Every single year, management has to face the owners at the annual general meeting, which is governed by Section 96. But here's the catch. The due dates are different for a newly incorporated startup versus an established company like, say, Infosys. For the first AGM, the company has 9 months from the end of its first financial year. But for any subsequent AGM, the timeline gets tighter, within 6 months from the closure of the financial year, with a maximum gap of 15 months between 2 AGMs. Guys, the absolute most common mistake students make here is applying the 3-month ROC extension to the first AGM. Remember this, extensions are only for subsequent AGMs. But what if members are upset and just can't wait for the AGM? Well, under Section 100, members holding at least 1/10 of the paid-up share capital can force the company to hold an extraordinary general meeting, or EGM. This specific timeline is a heavily tested 4 to 5 mark descriptive question format. Here's how it flows. On day 0, the company receives a valid requisition. The board must step up and call the meeting within 21 days, and the meeting must actually be held within 45 days. What if the board just ignores them? The requisitionists can actually take matters into their own hands and hold it themselves within 3 months from the date of requisition. Okay, time for a classic Socratic coaching question. Imagine you're sitting right there in the exam hall and you see this. How many days of notice are required to call a general meeting? Your brain probably instantly screams 21 days, right? But be careful, this is a very, very common examiner trap. The correct technical legal answer under Section 101 is 21 clear days. So what does clear days actually mean mathematically?
It means you must completely exclude the date the notice is served, and you must completely exclude the date of the meeting itself. If you literally just add 21 days to your calendar, boom, your notice is invalid. Please, do not lose silly marks on this technicality.
So the meeting day finally arrives, but you can't even start the meeting unless you have a quorum. That's the minimum number of members required to be present, governed by Section 103. For a private company, it's super easy, just 2 members personally present. But for a public company, it scales up with the size of the member base. 5 members, 15 members, or 30 members. And I need you to hear this loud and clear. Proxies do not count towards this quorum number. It's only members personally present. Let's move into Part 4, proxies, voting, and resolutions. The quorum is met, so let's break down the mechanics from Sections 105 to 115.
So if a member simply cannot attend, they can send a proxy under Section 105. But listen, proxies are strictly limited, and you really need to spot these limits easily in case studies. They must use Form MGT11, they must deposit it at least 48 hours before the meeting, and one proxy can represent a maximum of 50 members, holding up to 10% of the share capital. Practically speaking, a proxy is just a silent voting machine. They have absolutely no right to speak at the meeting, and they cannot vote on a simple show of hands.
Let's test that exact knowledge with another classic true/false twist from past papers. True or false? A company wants to be extra organized, so it writes a rule in its Articles of Association requiring proxy forms to be submitted 72 hours before the meeting. Is this valid?
The answer is firmly false. Actually, scratch that, it's absolutely false. That 48-hour limit is a statutory maximum timeline designed specifically to protect the shareholders' right to appoint a proxy. The logic here is simple. A company's internal Articles of Association can never override or make a specific provision of the Companies Act more restrictive for the shareholders. The 48-hour rule is absolute. Now, today, most major decisions in large companies aren't made by raising hands in a room. They're made via e-voting under Section 108. The study material has this massive 15-step procedure, but let's digest it logically into 5 easy steps. Step 1, the company announces a cutoff date to determine who is eligible. Step 2, remote e-voting must be kept open for a minimum of 3 days. Step 3, it strictly closes at 5 p.m. the day before the meeting. Step 4, during the actual GM, voting happens only for those who haven't already voted online. And finally, Step 5, the independent scrutinizer counts everything and submits a consolidated report within 3 days. Simple, right?
Now, some corporate actions are just so massive that Section 110 dictates they must be done via postal ballot. This ensures every single shareholder gets a say, even if they don't attend the meeting. You need to memorize these critical items: altering the object clause of the memorandum, shifting the registered office outside local limits, issuing shares with differential voting rights, and a buyback of securities. If you see a board of directors trying to pass any of these at a normal GM in a case study, you instantly know it's a violation.
So how do these resolutions actually pass? Section 114 defines ordinary and special resolutions. Let's just translate the legal jargon into simple mathematical thresholds. For an ordinary resolution, or OR, the votes cast in favor must strictly exceed the votes cast against, basically greater than 50%. But for a special resolution, or SR, the votes cast in favor must be at least 3 times the votes cast against. That translates to at least a 75% approval rate.
And what happens if the management just decides to ignore these rules? Well, let me punch in this heavy number: 3 lakh rupees. This is the maximum penalty on the company itself if it fails to maintain its registers under Section 88. The law has teeth, guys, and memorizing these key fines is crucial because examiners absolutely love testing your knowledge of consequences.
Finally, Part 5, exam traps and wrap-up. Let's lock these core concepts into your short-term memory before you walk into that exam hall. I want you to mentally take a snapshot of these master timelines. This is your ultimate last-minute revision hack. Notice of GM, that's 21 clear days. Depositing a proxy, 48 hours. An SBO filing their BEN1, 30 days. Filing that massive MGT7 annual return within 60 days of the AGM. Burn these numbers into your memory for sure.
So as we wrap up this masterclass, I have to ask you, have you mastered the forms, the timelines, and those sneaky examiner traps? If you understand the underlying logic of corporate transparency, if you remember what clear days actually mean, and if you know your MGTs from your BENs, you are going to absolutely crush this section. You've got the knowledge, now go conquer that corporate law exam. Thanks for joining this explainer and happy studying.